Welcome to Conflict to Connection, the podcast that helps families navigate separation with compassion and understanding. I'm Mitch, a child consultant at Civilised Separations, and I'm joined by my co-hosts, Bill and Bella. Together, we tackle tough conversations about divorce, co-parenting, and creating healthier family dynamics. Whether you're navigating a separation or just looking for better ways to connect, this podcast is here to guide you every step of the way.
Hi everyone, it's Mitch here coming from the editing room at Civilised Separations. I just wanted to add a quick note before we get into today's conversation. James Pirrie is a multi-talented man that wears many hats. So this conversation covers his perspective across being a lawyer, mediator and arbitrator. James also wanted to flag that he's a big fan of cross-discipline collaboration. The discussion in this episode about how collaborative work has room to improve is in reference to the formal processes of collaborative law. All right, enough from me. Let's get back to the episode.
So welcome.
Thank you.
So I'm just going to jump straight in and ask you, James, just to say a little bit more about what you do for the listeners that might not know, and a bit more about what you do with your company as well.
That's a tough question.
Yeah.
I didn't really like Catcher in the Rye, but I did like the one line where he talks about stopping kids running off a crazy cliff.
Okay.
I think that's what I'm doing a lot of the time. It's just trying to highlight the risks of litigation and trying to shepherd people towards something that might be better. So my firm does litigation if it's needed, but I'd much rather find a better way forward. I think particularly now where the system is so under stress, and in fact the system's saying don't come to us because we're not best. So I guess that's what I'm doing day in, day out, is trying to find different ways. So arbitration, mediation, one lawyer, collaborative, whatever it is. And I guess a lot of it is about recognising that lawyers don't have most of the answers. Most of the answers are from other professionals, and we need to find a foundation that we can bring them in and listen to them a bit louder.
That's really interesting. And what are those limitations that you're talking about the UK legislation within family law?
So at the moment, it's going very slowly. You know, if you start into a process, it'll be a year for kids and a year and a half or two for money. If you have to go all the way through to the end. And I think most people who've started it then get to this point where they go, look, we've got to get it out on any terms we can. And so then you're ending up cobbling together quite crude deals. I was talking to somebody this morning about, why don't we sit down right now at the beginning, and then instead of fighting out this thing, we can actually use all the money that we're saving to grease and solve or provide the settlement. So there's that. But I think also, and I'd love to hear from Bill about why it is that we instinctively reach towards court. I've got my theories about it. His are probably better than mine. People sort of feel that need to reach for a judge for vindication or I suppose to be told that they were the good guy or something going on. And yet that isn't really where our best solutions lie. It's sort of weird, isn't it? We've got a law which says mums and dads know best. That's more or less what Section 1 of the Children Act says. Only make orders if it's better than not having an order. And yet the court will jump in there time and again to do it. Parents aren't really facilitated or supported to make their own decisions once that whole process gets underway.
Yeah, so are you saying that basically in the start of the divorce process, it's just straight to lawyers? Nobody actually thinks about any of the other mediators? Because I think in terms of a societal thought that when people think of divorce, they think of divorce lawyers.
Yeah.
That's pretty much it.
Although the research now is saying not. If we reach out to fair shares, it's saying, sub 40% go through lawyers or have any legal input at all. And the result of that, of course, is a fast track, I think largely for women, but certainly for the financially less well-off party. They're descending quite sharply, taking the kids with them into poverty and suboptimal settlement. I have to keep reminding myself that my keyhole into what I think is true is a very narrow one. I just see a very small portion of people. And we're all held back in that way. We have our judges as our champions trying to redesign their system. But of course, they're doing it from a different segment of society. So they know very little too. They may be brilliant, but I think it must feel for them like trying to push a rope. They're trying to keep people out of their system, but they don't really know enough about what's going on. And it's all upstream. It's all with you guys. What are the answers?
It's a good question.
Yeah, I was thinking about how I can remember one time someone describing family law as, I think the word was centripedic. And what it meant was that the judge is at the center of it, and everything that occurs naturally expects everything to end up with the judge. So everything within the system is geared to the judge eventually making a decision. So it's kind of a weird scenario where the courts are saying, please don't use us. And the judges are saying, well, I'm not really equipped to deal with situations that pertain to relationships. And yet the system eventually always drives everyone to that central point, which is the judge making a judgment.
Wow. So the one in the middle is actually trying to push it all away in a centrifugal way, and we're all being centripetal.
Yeah.
Yeah, very good. I've always thought about it as this brutal walk up a hill, but just imagine it's a really horrible walk, and you kind of fight your way up there, and eventually you end up with this person who's in a sort of pretty horrible stone hut, who's got a queue around the block, and they're just having to pump out the decisions as fast as they can. And I'm amazed about how they manage it. You know, I live and breathe and, you know, just worry nonstop about my clients. Yet as a judge, you're having to, you know, you've got an hour to get your head around these people and then make these sliding door changes in their lives. It's terrifying, isn't it? Thank God I'm not a judge.
Yeah, I mean, I can't even imagine the stress that takes to make a decision on the basis of, you know, as you said, an hour possibly could be the longest amount of time that they spend with these people.
Well, there is this moment. I mean, if you go all the way to a final hearing, then they do have the time to properly get into it. But it's a fraction of a percent that get to the final hearing, because most people aren't going to get there. They run out of path along the way. And so if only we knew that, if only people knew that in their bones, and perhaps if more of the professionals were stronger about taking that line, then people go, oh, right, so given I'm going to fall off this bicycle somewhere along the way, why do I actually bother getting on it? Okay, now let's find a different way.
When you're talking about finding a different way, what do you think about the terms of collaborative law and working in tandem with mediators or social workers? Because I know people do that already.
Yes.
But have you seen successes in that?
I think most people would regard collaborative as one of our great failures. My firm sort of helped to bring it in 2003. And, you know, I've always got a few cases going, and a few people always have a few cases going, but it didn't take over the way we thought it would. But it did do a couple of things which have been really significant. And I think one of them was this idea that you need to be multidisciplinary. We need to really stop thinking that the lawyers have all the answers. And I think one of the things that was really drummed into us was trying to stand with our non-law colleagues, that's a terrible term, but we'll do for now, properly as equals. Okay. Because the court system is all about, we'll take in a bit of professional guidance, but it's only what we can understand within the legal system. So it's like we've got this wealth of wisdom, but going down a very tiny tube, so most of it we can't hear.
That's really interesting. And I know, Bill, you have your own opinions about collaborative law and how that's been for you. What, from a mediation standpoint, do you feel about collaborative law?
I was once a member of a very good collaborative team in Sydney in Australia. It took a good 5 years before it started to in any way function well. I think we did about 6 cases, and 5 of them were a disaster because of the clash of professional approach. So the clients were really suffering, I think, from the effect of having lots of different people with lots of different ways of working. So they were infinitely worse off than they would have been with any of the individuals within the team. They just stayed with the lawyer, they just stayed with the mediator, just stayed with the child consultant. So they you know, so I think it takes a very long time for that sort of team to become better than that you would be if you were just with an individual. And I think the really valuable thing about the team was that you had not only transparency in terms of everything that was said was known by everybody within the team, but you had the ability to kind of gently nudge each other in helpful directions, because you'd notice on occasions that someone would be getting on a bit of their own bandwagon to the disadvantage of the greater good, if you like. So the child consultant perhaps might become overly sort of annoyed with the lack of the capacity in the parents to understand what they were doing, or the lawyers might become very invested in their own client, and so the balance would get lost. But you had that easy way in which you could all sort of gently herd each other into the same direction, and so you got the greater of the sum of the parts, if you like. But that's big and clunky, and it took 5 years funding to get it going. So the organisation I work for funded these people to meet week after week for years until they actually got quite good. But that's a big ask.
There's probably a graph you could draw, isn't there? Because I think that the more people you bring into the room, the harder it is to manage. So I'm doing, when I'm mediating on finances, I'd usually try and work with a financial planner, and that works quite well. But I know that every time I add more and more people in, I know I've got a richer conversation. But God, it's hell trying to manage it.
Yeah, it feels like you're not really getting anywhere.
Yeah.
But it's still richer in your conversation, but actually is the outcomes happening anymore?
It does slow it down.
Yeah.
It makes it hard to bring it over the end. So there's probably a way of, I'm sure that we'll find eventually what the way forward is to do that, and it'll be easy. We think, well, why didn't we do this before? And that is sort of fascinating when I look back on some of the developments we've seen, because the ones that work, we've just embraced, and we've gone, yeah, that's obvious, and we just get on with it. And we stop thinking that was a real step forward. And it makes us sort of feel a bit helpless and hopeless at this stage, where we think, oh, how are we going to make this work? But actually, as a community, I think we are quite creative. I think we are finding things. It's just that we forget to remember how great we were when we found them, and we took these great leaps forward and so on. So let's have another one, please.
I mean, there's definitely, I'm sure that you both have thoughts when you're in your own, we got two different industries here, but working collaboratively. And when you do that, I'm sure you both have different thoughts about what could be done to make it better. Do you guys have any ideas about how we could improve things in family law or mediation that could help that collaborative aspect?
Well, I yes, I definitely have some.
How long have you got?
Thoughts. I feel that conflict has come from a place that people are not aware of, I suppose. I feel that conflicts come about because of unconscious forces in play. If you look at someone's childhood and look at some of the experiences they've had, they might have ill-equipped them to manage relationships well, and so they lack perhaps awareness or capacity to be reflective about how they are and how the situations come about. So when they look to see what's gone wrong, they very much look at the other person and say, well, clearly this is only happening because you're like that. They don't think, I can be difficult sometimes, and I know I can be sort of defensive, or I know I can leave people to feel that I don't really care about them. So they don't tend to come with that knowledge. So anything that happens that doesn't pay attention to that, from my point of view, is problematic. If you don't know why you're in conflict and you're only addressing the topics that the person's come up with, like the things they can't agree on, then you're going to be sort of, at best, sticking a Band-Aid on something. You're not really dealing with how it came to place how it happened in the first place, where the conflicts come from. No one wanted the conflict. You'll often find if you say to people, how come you're having an argument? People will go, well, I don't know, I didn't want it, but obviously he did. Go to that person, they say the same thing. So conflict sort of inserts itself in between people and provides tons of evidence to keep them both going, where both feel like a victim, both feel like they're being unfairly attacked or treated poorly. So I think any process that doesn't deal with that fundamental cause for the conflict is going to be at best a temporary Band-Aid. You've got to deal with how come the conflict happened. You've got to understand about the nature of relationship, and if relationship doesn't allow two people to interact with each other and come to a good point with each other, then again, you need to take into account something that's a context that's very pivotal in how come people are not getting on with each other. Because usually you'll find if you ask people why they're in conflict, they'll highlight one very specific aspect of their lives and say, well, that's it, that it all centers around this thing, like, we can't agree on what school the child should go to or whatever. And I don't like the other person's approach. I don't like the fact that they don't listen to me. I don't like the fact that they don't take my opinion into account. I'm annoyed as a matter of principle about how they behave when we talk about this topic. So the topic becomes the center, if you like, of the whole discussion. And actually the topic's just nothing more than a symptom from my point of view. So I feel that if you can have a combination of law and that degree of awareness of where the conflicts come from and to what degree is this relationship not allowing them to have differences of opinion and still get on. If you can have a combination of the law and that, you can have the structure of the law, you can have the credibility of the law, you can have the nicely defined outcomes as to what we're going to do in terms of everyday logistical sort of arrangements, then that's a good mix. But you've got to have that relational awareness, I think, before you can genuinely help come up with something that's going to last. Otherwise, I fear that what you cobble together will just last until the next issue comes up that people can't manage.
When I've watched you work, that's the bit I've always thought, that's the transformation, is that you focus on people working on how they work to get them to actually be a better team to solve these issues. And I did a training with Ken Cloak the other day, and we'll put a slide up if we can, which was really talking about these 6 levels of conflict. And, the first one is basically stop the rowing, and then the second one is solve the problem. I'm thinking, well, in court, we don't even stop the rowing. In fact, what we do is we really exacerbate it. And I'm always a bit ashamed to say this, but I know that when we step into a case as a lawyer, we're looking at it really differently in a way that is not good, James, frankly. We're trying to hunt out those little nuggets of gold that we know are going to land with the judge. Okay. And what we actually do is we take people and we turn them into a bundle of caricatures, really, almost, of characteristics that we think we can kind of pull out and play out and think this will work. So there's no attempt to try and respect the people and to try and deal with this in the place where they are, which is what you're talking about. So we're not even dealing with level 1. We just go straight to solving this particular problem, the school they're going to, which is what you're talking about, or whatever the problem is. And of course, that means that it's just waiting for the next problem to come along, isn't it? So the essential, as I see it, is that we have a system where the court is doing the least sophisticated and probably most problematic piece of work, but it has trumps. What court says eventually is what will happen, which means that everyone sort of is always quite attracted by that idea about reaching out to mum and talking about how unfair it is and how badly treated they've been and how bad the other person is. And so that's just a very alluring mix. And it's almost as if we've been brought up to believe in that and to reach out for that in a way that isn't very helpful, whereas we ought to be doing the Bill job of reaching back into making this partnership work.
Yeah. I definitely also think that having the children have a voice should be almost consistently happening. I often think that, children are probably in a situation where against their wishes, separations happened. So they weren't really consulted. And then when the family's looking at what shape is it going to take in the future, if they're not asked to have any input into that either, then how can the parents sort of knowingly construct something that's in the children's best interest when they haven't heard?
And I think the other advantage of that is that it would pull you away from what I do. So I've always been interested in the law in the way that we never sit down with the former partner of our client. The system is one that keeps us at distance, which is why you have to be really quite energetic to make sure you have those early meetings to actually go, oh gosh, you're a human being, and what you're thinking and where you're coming from is actually quite sensible, and now I need to think about this case differently. You're not just a sort of a collection of irrational behaviours that I need to sort out and sort of go, look how bad she is, look what a terrible human being, and we need to sort of think about that differently. And in fact, as you go through the process, what's interesting is that the people that, whose lives it is get further and further back in the mix. I went to the House of Lords, as it was back in the noughties, on this case, and it was extraordinary. By the time we went through the process of sitting together, and then we went to a first appointment and a financial dispute resolution hearing, and then a final hearing, and then another final. Went on and on and on. But anyway, by the time you get to the House of Lords, your clients are in the public gallery. It was amazing. They've been pushed back to being spectators into this thing and there's 40 lawyers between them and the people making the decision. Yeah. And, they're the ones who become the players.
It's really interesting, that idea of not being allowed to sort of tap into the humanity of each other.
That's the point.
Yeah. I remember hearing someone talk about how a group of young Palestinians and young Israelis were brought together, and they were kind of going through some sort of peacemaking process. And one of the participants said, "It's impossible to look into your eyes and hate you at the same time, because the information coming through your eyes would contradict the simplicity that you otherwise have to adopt if you want to just hate someone. You've got to be very linear, you've got to be very rigid, you've got to really narrow them down to something very tiny, really, in terms of who they are, to remain antagonistic towards them. Because otherwise, if you look in their eyes, you see the totality of them, you see how complex they are, you see how there's many aspects to them, good and bad. It's very hard to sort of narrow, to be hateful towards something big."
And then I guess, Mitch, with your work, when you feed back around the children, that's when they're almost forced to look each other in the eyes and to think about their kids and so on. That's why it's such powerful.
They have something that they can contain over, that they can come together about, not necessarily seeing each other completely eye to eye anymore, but they have something that they can hold on to that's the same. So the kids are the thing that are in their point of view now. They're the thing that they have to cooperate over to make sure that their kids then go on and be the best humans that they can be. So they want them, all parents want their kids to be the best that they can be, to go on and be an astronaut or whatever they could be in the future. And what they're doing at the moment isn't necessarily helping their kids get to that point. And that's what we're trying to show them in a very kind and loving way, that really what they need to do is find a way of cooperating in some way together as co-parents, that their kids can then go on and be really successful and be everything that they can be.
And I worry that so many parents come into this chapter without knowing that that's the goal. It's as if they're sort of being set down to play a board game without ever having been told the rules and not really knowing how they're supposed to get around this board or what the objective of it is. And so they just do the best they can. And I think they're reaching back into a sort of a complaint, what we did when we were very young, which was, if something was wrong, we go and explain it to mum about why it was so unfair and point the finger at somebody else and then wait for mum to make it all right. And that, I think that's almost as if that's bred in us as to what we have to do. Whereas what you taught me was to do something very different, when you talked about the parental alliance, which I think is now one of those things which become commonplace, but I know that it was with you, but how do you make that strong? And then, I see. All right. So I've got to show you that I've got your back and you've got to show me that you've got, all right. That's what we're doing, is it? Okay.
I had this image when you were speaking about, in the House of Lords, and it was, they were literally sitting in the opposite, or could see them sitting in the opposite sides of the room and all these people in between them. And I just thought, I could just see the kids in the middle, like their parents through the whole process, that the law is kind of separating them. This process of family law is just kind of pulling these parents apart. And they've got their kids in the middle that are going, oh my gosh, where are you going? Like, I need you both here to help me out.
Interesting. That's your perspective. Because, of course, in that process, the kids have become invisible.
Yeah.
They've just become a collection of attributes, really, that maybe their needs, because, okay, we've got 3 kids, so we're going to have 3 bedrooms or whatever it is, or they're these different ages. So they're definitely not in the centre, however much everyone knows that's where they need to be. I unfortunate. But in a way, what you've got is you've got a system which is saying, look, don't use us unless you have to.
Okay.
But if you have to, we're going to do the best we can, and this is the best we can do.
Mm.
And there's a whole lot of things they're not going to do. They're not really going to understand the children. They're not going to take into account the history of how people have got here. They just can say, well, this is what we've got, and this is what I think is the best for going forward.
Do you
Quite
think
crude.
it's a possibility that we can improve on that? Like, as you're saying, obviously we don't want them to use the courts, but if they have to use the courts, this is the situation that they're going to be in. Is there any way that we can improve that situation? If they have to go to court, can it be better?
And I think the answer to that hinges upon a family you've got in your head. What I've tended to find over the last few decades, that when I talk about things, people are going, you're just talking rubbish. It's usually because you've got a different family in your head from the one in my head. So in my view, everything should start with mediation, because that's the place where you have the conversation. I mean, I know there are some high-risk families where, okay, that's not on. But for the most part, you actually stay in mediation to have the conversation about what can work. And maybe that gets you most of the way there. And maybe we need court to decide that final plank in the bridge. Yeah. But it shouldn't be doing it all. And of course, the problem that we've got at the moment is that if you don't complete the bridge in mediation, then it's as if the bridge has never existed, because you can't share the contents of the bridge. I'm overdoing this metaphor.
No,
I'm trying to stop.
I like it.
I can't stop it. You're not allowed to tell the judge about what happened in mediation. So there's a system where you can bank what happened in mediation and then go to an arbitrator to get the final bits. But I'm not sure it's ever been used. So, you say, could it be made better? Gosh, there's lots of room for better. There just needs enough of us to decide what better looks like and start to embrace it and run with it.
That's interesting. The idea of mediation not being kind of finished enough. Because I know I've often been a struggle for me, because I'm primarily interested in talking to people about relationship, and the sort of nitty-gritty nuts and bolts of something that could become perhaps a legitimate legal document is something that I'm not, big on.
Really?
Believe it or not. I can remember us working together where I worked with some people, and they had kind of got to a point where they were on board with the idea of coming up with a document with each other, but concerned perhaps about my capacity to create that. And so we all sat down together and we nutted it out.
Right.
And you had a big screen up there, and you just, as they talked,
right,
you wrote. And then there was a document that would be, I think, considered to be valid or acceptable by a judge. And I don't even know if it needed to be taken to that point, but it was solid enough for them. Right. So they couldn't just leave with this vague sense of we need to be nice to each other. They wanted something more than that. So in a way, that was an example, I think, of what perhaps needs to happen more often, where you get the best of both professions and not deal with the rub. Because does seem to be this point where professions, and you think about, how do you get to be working in an environment where some degree of psychological capacity or some degree of therapeutic skill is required. That world you went to, where you got to be good at that, the university you went to would have been of a particular type, and you would have been to a particular type of lectures, and you would have read particular authors, and you would have got to that point where you now are good at that. And of course, the lawyer's been to a different university and read different books and been exposed to different ways of thinking. And that seems to be the rub where the clients are really dealing with the disadvantage of us being in different silos. They're having to deal with the fact that we don't sit comfortably with each other because we've learnt different things. We've been influenced by different schools of thought.
I was really interested by that as well, because I know that you're a lawyer mediator, and that almost sounds like, to me, a slightly contradictory line of, the line of thinking almost. You got mediator to one side and you got the lawyer on the other side, and they have quite different thinking. They both want the same goal, what's best for their clients, but sometimes they come from different points of view, as you're saying, reading different books and brought up in different ways, and how things should work in relationships and going forward in separation. For you as a lawyer mediator, what's that like? That kind of, does it feel contradictory at all? Might not.
No, I probably do it in a less effective way, though. So I'm very conscious when I work with people from a sort of relational background, that I think people are surprised. They're much more challenging of clients than I think we as lawyers are used to being, maybe because we're used to doing what we're told a bit. I don't know. But I always sort of find when I work with people from your profession, Bill, that you're pretty hardball with them and you're quite challenging of them in a way that is really helpful. And I wonder whether, as a lawyer, one of the problems is perhaps I'm a bit too focused on the outcome. I try and be more Bill. Obviously, we all try and be more Bill, don't we? To channel our inner Bill and try and kind of focus on the relationship too. But I think I see the job done when it's all kind of written up and we know all the things we're going to do. Whereas you'd see the job done when they've actually got a new way of being together. And I know that's more profound.
No, but yes, I mean, it's true to say that from my point of view, if I've done a good job, they don't need something written up.
Exactly.
Because hopefully they've understood enough about each other and they've got enough of a plan about how they're going to go forward. But in reality, I haven't done that good a job and they aren't necessarily happy to just go and just do it. They need more.
There's probably a bit of falling back so that though, they've acquired this strong way of being, which isn't so great, and then you come along and you actually encourage them to this new place. But I imagine there's this bit of a slip back, which is why perhaps having some of the nuts and bolts of what they're going to do written up is helpful. So I've just been working on prenuptial agreements at the moment, which I'm horrified about how we do. So I know that you're talking a lot about conflict to connection, whereas a prenup, I think, is connection to conflict. So, really? A couple come to you and they're in love and they're looking forward to putting their lives together and they're really put through the ringer. And what I'm trying to get people to think about more is stop thinking me, which is about how do I protect my assets, start thinking about we. This is this opportunity for you to plan out how you're going to both be safe together. And if we could only get people to do that, then it'd be more useful. And I was feeling a bit Bill-like when I was writing up a prenup recently, which is much more about intentionality and about how they were going to get in some help from financial planners and so on, and how therefore this is what they were going to do for their future together, which is a more useful way of being. But if that document actually ends up in front of a judge, they're going to be going, what is this, Pirrie? It's absolute nonsense. Whittering on as usual. I don't know. Anyway, so it's challenging, isn't it? You've got to make it work in both domains.
So you kind of have that slight thought in your head of that little bit of backlash that you might get from a judge, like, where are you going here? What are you talking about? This is a bit wishy-washy.
The second that you stray away from doing the best from the people who
are
in the room with you, you're doomed. And I think there's too much of that, isn't there?
And about those people in the room with you, those clients, I mean, in terms of what you've seen across family law and separation, is there many clients that are coming out with feeling happy, in the happiness in the ending?
Out of the law?
Out of the law. I mean, you could say in terms of people that have been to mediation as well, but I'm more wondering from your point of view about coming out of the law.
I think mediation has real capacity to generate, a harmony and a sense of having done it really well. I think it does do that. In terms of coming out of law, over the last 40 years, there's been maybe two who've come out going, oh my God, James, you are a magician. Okay, maybe there's a couple who've sort of been, that was okay, but it's largely not. And how could it be? If you think about how long let's just spend on children, it's impossible to come out of the law feeling good. I really believe that, because it takes so long and the parents are encouraged to be polarized. So what's going to be good about that? That, and these kids are having to live with this uncertainty going on for month after month after month because it doesn't get decided anytime soon. So that delay is tough. The costs are always tough. There's no excusing it. The solution that they had at the end was what they could have had right at the beginning. When you talk about somebody was just talking about how a system, the purpose of a system is what it does. So the purpose of the family law dealing with kids is about sort of polarizing the parents so they can never ever work to get together again, and imposing such delay on kids that they're sort of, not destroyed, but certainly hurt by it.
Just thinking about how that feels for you, and also for other lawyers out there that are having to feel like actually only 2 of the clients that I've worked with in the last 40 years have come out happy. That can be quite intense, I feel like, a feeling of...
Yes, I mean, if I'd encouraged them towards the court, then I would have stopped a long time ago.
Yeah.
But I think if I'm back on the catcher and the rye going, okay, they were the ones who slipped through.
Okay.
I did my best to help them find a good way to do this. And for whatever reason, I didn't get there. So I think in a way that was all right. I think it would be hard if all you were doing as a lawyer was hardball litigation. I think that would be tough.
Yeah.
And unless, of course, you were doing it in cases of domestic abuse, where, obviously you need to be bringing in the law, and you are actually, that's a different set of motivations, I think, isn't it? That's more about protection.
And I was just thinking about, I know you guys have worked together before, but when you have worked together, I was wondering what you found that were the interesting factors about what each other do in terms of your work, and also what things that you've gone, oh, that's really interesting, or, oh, didn't realize that you were doing that, or contradictory things. So when you've worked together, what are those aspects that you found in those cases?
I used to love the way that Bill would strip out the sort of the fixing it points. So I'd sort of nail some things down, and then Bill would pull out the nails. No, I don't need any of that. So the bit that was absolutely uplifting is I sort of have this parenting agreement, and it was like, yeah, right, we can put that in an appendix. But actually, what you need up front is this stuff, which is, what is it that you're doing that I react to, and what is it I'm doing that, how to create that better relationship between them for sorting problems out. And the top line mediators give me that time and time again. I don't seem to have learnt it over the last 30 something years, or how long I've been doing mediation. I keep on trying to, but I don't quite get there. So this idea that once we've got their relationship solid, our job's done.
Yeah.
Whereas we go, no, Bill, I've got this list of 45 things we've got to agree.
Yeah.
Well, I'm of course impressed with that capacity to sort of nut into the detail and come up with something. And also, I think a thing about working with you, James, is you don't bring a kind of an aggression or a kind of an anger, or you don't seem to be encouraging people to be nasty to each other. You seem to be very much at odds with that. So I often think there's a big contrast between the reputation that lawyers sort of have sort of globally and what they're actually like individually. And
that's interesting.
You're very happy to be sort of. I remember once this therapist that I really liked, and he was the most. I'm not suggesting this is you, but he was the most shambolic, sort of chaotic. Remember Columbo, that sort of detective?
Yeah.
Just before you go, that sort of seemingly non sort of clinical or sort of outcome focused. You don't seem to be outcome focused. You do seem to be relationship focused. You do seem to be very good at putting people at ease and them feeling comfortable and safe and perhaps braver than they otherwise might be.
He's being nice, actually. But when you work with Bill, you don't get a word in edgeways. He's really
Yeah,
goes on.
Just rambling on.
That's true. That's true.
And obviously, that's quite a good relationship that you're having in terms of the collaborative relationship between the both of you. I'm interested in the fact that there may not be people in the mediation world that work very well with the people in the law world, and vice versa. Have you ever had experiences where you've kind of gone into a situation with a lawyer or a mediator and been like, oh my gosh, this isn't going to work?
Yeah, it's definitely. Sometimes you feel you're really making progress, and then the lawyer will throw something in that absolutely nudges everyone back. Hugely, the mood is lost. And I don't think that's about the lawyer wanting to do that. I think it's just because they're operating in a very different culture, and it's problematic to kind of operate in both. I sometimes feel I have to go back and deal with So the people are already upset with each other anyway, so they've already sort of nudged down the road of being, hostile and angry with each other. And then they've kind of got involved in law and gone further down that road.
Yes.
So not only do I have to deal with the fact that they've taken themselves down that road somewhat, but the lawyer's taken them even further.
And that is then a problem about how do you deal with that. And I think we probably have to be better at bringing lawyers into the room, because actually then once you bring those two views side by side, they can't coexist. They are inconsistent estimates of what's going to happen. And they can't both be right.
The lawyers are slightly disconnected from the relational aspect then, because you're kind of on one side, don't really getting to view the other person.
Yeah, so when the lawyers are outside the mediation, supporting mediation, they're going to really just be giving a legal view about whether Bill's taking you down this crazy place. Why are you going there? But actually, and you're entitled to this. So when we sit with our clients, we're very good at showing off, I suppose, and trying to say, well, I could do this, I could do A, B, C, D, E, aren't I amazing? Watch me. And I think that's probably heard as being, these are my rights. I know in America, a couple went in to see the same lawyer, changing their name to prove the point. And of course, ended up with very, very different views about what they were certain to get. And I think that goes on a lot. And I think that you could run the same experiment here and you get the same answer. So I think that if as a mediator, you then bring the two views together, that is actually a thing of value for the couple, who are now getting a richer version of law. So instead of it being a partisan version, which is actually very two-dimensional at best, they actually think, oh, there are different ways in which this could plan out. And I think then, against that uncertainty of the law, why wouldn't we reach for a relational solution?
So if we bear in mind that the collaborative idea, the idea of the team has not really taken off, and it's clunky, and it involves lots of people, and it involves lots of potential clash of cultures. Are the lawyers staying out as an indication of almost acknowledging that they're not going to add value, or that they're not welcome? I mean, why aren't the lawyers pushing in and saying, I should hear this too? Because are the mediators saying to the lawyers, no, you can't come in? I mean, well, how come?
There may be a bit of that. I think collaborative has ended up looking like a very expensive option. There's too many people around. I never really understood why it was that we have one relational person to do all of the relationship and one financial person to do all of the finances. We need two lawyers to explain what the law is, which shouldn't take more than 10 minutes. I never really understood why we needed that. And I suspect that probably what's emerging, I'm not sure yet whether I'm a fan of the one lawyer model, but I think it could be harnessed in this way better. But I think you've got to decide who's the anchor and who's the gatekeeper. And I think that if we had the relational mediator doing that task, and possibly then, involving, are we ready to have this conversation yet? Because I think a lot of things fall over because actually mum and dad aren't yet ready to have this conversation. But then, of course, kids don't wait, do they? So how on earth are we going to manage that? Well, perhaps we just make shorter term, more limited decisions. But if actually it was anchored around a relational mediator who then brings in the law, we're a bit stuck on this, or we think the rights might be this, what does this look like? And you actually had neutral views of the law. I think that works quite well. I've started to do that, where I'd bring in a barrister I would say, oh, well, actually, what's this about? And you can ask quite naive questions, and I think people then get quite a good idea about the uncertainties or the bell jar of likelihoods of what's going to happen. It's quite a good way of...
Bringing a barrister would give you perhaps a little potted micro version of what a judge might say.
Sure.
Okay. So that, I mean, it's obviously good to know, isn't it? You're good to know that how things could play out.
And it's really good to know either that there is an answer. Okay, well, we better kind of hold that in mind, or that there's no idea of what the answer is, because that's quite a good thing to know. And I think often if you're getting only your lawyer's version of it, there's probably too many filters going on for you then to come into the mediation to have a profound idea between you about what's likely.
Yeah.
And that's why I think you get this thing about wobbling over a bit in mediation.
I'm kind of wondering if right from the start, rather than suggesting the client gets involved in what could be a big and possibly an expensive process of lots of people, if you could have from the start, if let's suppose they started with mediation, to start straight away talking about the inclusion of a lawyer as a given, of course, why wouldn't we? And we know this lawyer really well, and this person's not going to nudge this in a direction that, is away from what we want to do. Or if the lawyer is to say right at the beginning, we will, of course, be involved, the mediator or the relational person who has that. So you start from that premise. Of course, we'll all be there, and of course, we'll all be on the same page. Whether the clients would go, okay, whatever, I don't know. I'm not. So I kind of feel like in some ways it's our kind of professional boundaries that they suffer from the consequences of.
That's very interesting, because we've had a big law change earlier in this year, which was properly, for the first time, I thought, closing the doors to court. The courts were now given powers to say, do you know what? If you've not engaged with this, if you've not engaged meaningfully with the non-court space, you can pop out again. So it's like a revolving door.
Oh, right. Okay.
I don't think it's bedded in as it should. I think it's crucial that the lawyers really push it so that it does. So, we've got this opportunity to change culture so that our courts aren't overloaded, and so that court is not the sort of knee-jerk reaction base you go to. How amazing if that happened. I mean, and the court is saying, okay, we get it that sometimes you need just a timetable. You need to ensure that somebody engages, but that's not us either. You can go to arbitration for that. And arbitration is another one of those things that hasn't really happened. I think it may be starting to a bit more now, but the fact that it went live in 2012 and here we are in whenever it is, 12 years later, and we've just got over 600, really, in total. And interestingly, even though there are many more children cases than money cases, the children cases are about 10% of the money cases in arbitration. So that's kind of unusual. But actually with arbitration, you've got this opportunity of really supporting mediation so that as you work out, if you like, an arch of what kids might need, but you get stuck on the keystone at the end, you can say, okay, let's bank the arch and we'll go and work out, is it Friday or Saturday, or is it this place or that place? You can actually go and get that from an arbitrator. And that would be a way of banking all of those beautifully crafted stones that we get out of mediation.
Just take it over the line. Yeah.
I mean, you'd say it's better if you just kind of say, well, we're nearly there. Let's do the keystone as well. And in fact, the only time it's nearly happened for me is I've been parachuted in on a couple of mediations to explain what med to arb would look like. And they went, yeah, right, we'll just go and finish this case off then. They go, thanks, James. Off you go.
I can imagine that it's that part of the collaboration. I mean, we don't necessarily, I'm sure that lawyers don't necessarily want their clients taken away from them, but what we were discussing before is about, and especially at Civilised Separations, about kind of coming in for a short period of time as mediators with clients, lawyers' clients, and maybe doing a bit of work with them so that they collaborate better. Sure. And then it's easier for the lawyers.
Totally. And of course, if this idea of child inclusion in all processes took off, which is what's been talked about and may well go live, then that would happen. The idea then is that even on a litigated case, obviously there's a worry about over-professionalisation for kids, but on more of these cases, even on finances cases, you'd come in. I've been doing a lot of work around variations, and that's where, 10, 20 years ago, we fixed maintenance, and now we're coming back and looking at it again. I thought, well, you'd never need kids around for that. And I thought, oh, actually, you really would. And what I'm finding in those cases is that these children are now needing to get a step up onto the housing ladder. And they're properly looking at what's going on with mum and dad. They're back there at it again, and is mum going to be okay, and what's happening, and all of that. You could have a very rich conversation around the history, and you could actually start doing some sort of peacemaking, which might mean that, they're now going to sit possibly on the same side of the auditorium at the university graduation ceremony, might even be on the same top table at, I've never had two top tables at a wedding, isn't it? And maybe it's coming.
Mums and dads.
Yeah.
Yeah.
Wouldn't that be nice?
Do you think as a lawyer that you'd quite like to be invited in more than you are? Like, let's suppose that a mediator or someone working more relationally with the clients was thinking it would be useful to have the voice that you would bring in, because I do think it's true to say that people have over time created an expectation out of what they want, and they do have an expectation that it would be something quite sort of legal, that finish off. So there you are, sort of hovering, happy to. I'm assuming happy to kind of get involved. Do you sort of? Would you like an invitation? Would you like to have a sense that you'd be invited into a process like that? Are you quietly sitting out there thinking, I'd love to, but
I'd love to do that. And I also think the barristers do it really well. I mean, I think people underestimate how cheap barristers are by the hour. They're really, useful. And of course, they're used to making these decisions really quickly, and they're the ones in court all day, every day, and therefore they're the ones who can give you a pretty gritty assessment of what court is like. So I think finding the right person is good. I also loved your comment about, are lawyers going to worry about losing clients? But what you'd want to be saying to lawyers is, you don't need to look any further than the Fair Shares report. When you think about the vast numbers who are excluded from this, who are having no professional input at all, it's not that you're going to lose work. You need to find a way making your process and your work more attractive. And that's what we're failing to do, or failing to communicate well enough at the moment.
Yeah.
So it would be great if we were being more open. And another one of my wheels, which we might pop onto your system, is to try and stop talking about process, but to talk about needs. And I think if you focus properly on, okay, what is it that you both need to reach this solution? And then you think about it almost like a computer circuit board about, okay, right, are we going to use a mediation board or a collaborative board, or what are we going to use? Now we can solder some components on it to ensure that these clients get what they need to get this job done.
So are you saying that the lawyers would kind of look at the clients and be like, here, what do they need? What do these specific clients need from us? And then get those people involved in a semi-collaborative way.
But query, is it lawyers or is it Bill?
Yeah.
Probably Bill. Most things are Bill. Because I think so often you're seeing their issues more deeply. You may not be very good at holding a calculator up the right way. I'm allowed to say that because you're being filmed. You're not allowed to hit me. But you are. You see deeply through what's going on between them, and I think that's what enables you to help them perceive what it is they need to kind of make this progress. And there's one little chunk on the clock, just one little segment, which is called law. I mean, I think people do need to know what their rights are, or their obligations are, to go, yeah, okay, I'm good with this, because otherwise they're going to be sitting in their garret in 10 years' time thinking, that Bill, it's his fault.
Yeah.
And they don't want to go into a process feeling uninformed either. Like, they want to come out of it feeling, I've got the best information that I could have had, and also I've had this relational advice that's been really helpful for me.
Almost. I just wonder whether going into the process, they're actually fine. I mean, I don't know. I've not done it recently. I don't have done it at all, really. I think they're quite happy to step whichever way they're led. I don't think they need to go in feeling strong about their rights. I just think that what they need is someone to say to them, look, before we're done here, of course we'll tick that box.
Yeah.
Of course you need to know that. Now let's think, what are the other bits that you need? And now let's plan our process accordingly. And that isn't about, let's start a process now that will leave you sort of unsupported and with no definition for 15 months or 2 years whilst we get to the end of it.
Yeah. Makes them feel lost almost in that situation.
It must be terrifying.
Yeah.
And what's amazing is how I find clients are just lovely. I don't know how they manage it. I don't know how they manage, that they've been through all of this and they're now managing this terrible process. They've got jobs and homes and families to run. And they've got this, which is almost like a part-time or full-time job on top. And yet they still are lovely. I don't know how they get through it so well. Perhaps I'm just lucky.
Yeah, I think it's true. I think they're lovely people caught in a process that's almost kind of trying to deny them their loveliness, and somehow they manage to maintain it in spite of that. And there's nothing finer than the look you see between two parents when you're kind of describing to them how their children are feeling, and you're obviously not shaming them or blaming them and just kind of basically saying what an incredible child and what a great job they've done. Where they just have that little look between each other at some point, and they're reminded of their humanity, and they're
You do
reminded.
see it. Like they literally go
They just go, ooh, like that.
like that.
When you're talking about the children.
Yeah. So you can see them connect. Not like they're not physically, it's not
No.
anything of extreme, but finally, the whole time they've spent like this, going, yeah, okay, whatever, and refusing to look at each other.
Yeah.
And then you talk to them about the children and you give them these kind of emotional moments of, you've brought up these wonderful people, and then they go,
And
we have, haven't we?
Is it fleeting, or can you anchor that and then go from there? Do you
well,
find?
you use that as a moment of a push. You kind of go, oh, there they are. They can see each other now. And then you kind of move on with the process, I suppose.
Yeah. They send you a clue that says, we're now ready to start to have a conversation at a sort of a higher level. First of all, it's like, no, I want to hang on to my old story. And you're twanging on their heartstrings and talking about the children. They give each other that little look. And it's kind of saying to you, we're now ready. You can now.
And I think I've seen you observe that and play it back to them and say, I noticed what happened then. I'm not so good at that. We've got lots to learn.
I think the fantastic thing about that, and when you go, I just noticed that.
Yeah, that bit.
That bit, yeah, because they love that. That actually it's such a good thing, because we don't notice how we are, and they don't notice how they're behaving. It's all so unconscious and instinctual. And the cues that we're getting from lawyers or the situation, it's like, as you were saying right at the beginning of this conversation, you go in and you pick out the characteristics of the other person. What have they done wrong? What's that characteristic that I can use in this situation to benefit you? And they're looking at all of these things as kind of cues about the other person. And then suddenly they go, oh, actually, you're a human being again. It's quite a wonderful thing to see. And then you pick up on it and you can move forward, which is really exciting. Yeah, I think that's us, unless you have anything else that you'd want to discuss.
It's been a brilliant time.
Yeah.
Thank you so much.
Yeah, thank you for coming. It was great. We have some lawyer knowledge.
Yes.
It's fantastic.
Yes, fantastic. Maybe we can have you come back again as we progress over time.
Thanks for joining us on Conflict to Connection. We hope today's episode gave you some fresh insights to help you navigate your journey. If you found this helpful, don't forget to subscribe or follow the podcast and leave a review. For more resources and support, follow us at Civilised Separations on Instagram, TikTok, and LinkedIn. You can also visit our website at civilizedseparations.co.uk. See you next time, where we'll be exploring ways to build stronger connections for a brighter future.